Oh, hey friends, it's Josh doing a walk and talk with Dodger. Trust and estate stuff that I think is just so riveting. Now, most trust and estates personalities online, of which there's a total of 7, have one little talk that they always do. Gets really high reviews. I've been resisting doing it, but I'm a slave to peer pressure, as you can tell by my lovely hair. And so I'm going to do it. It is, so what's the difference between a trust and a will? So the context of this little vignette is a California family. So a trust is a box, a bucket. You put assets in it, you retitle things in the trust into this bucket, and then you throw into the bucket a series of instructions. That's the trust document that says what you want done with the assets that are in that box. Now, there are some assets that don't go in the box. These are assets that have beneficiaries on them, like the IRAs or life insurance or annuities. Those assets don't go in the trust because the instructions, the beneficiary instructions, supersede whatever instructions are in the trust. So, for example, if you had an annuity somewhere and you wrote down in the on Schedule A of the trust, hey, these are the assets of the trust, and I've got this annuity over at Ameriprise, and I want it to go to my son Johnny. But if the beneficiary form on that trust says something else, it doesn't matter what you said in your trust document, because assets that have beneficiaries do not belong in trusts, because the beneficiary instructions supersede the language of the trust. So you've got 2 kinds of assets so far. Those assets that go in the trust, called trust assets. Those assets that have beneficiaries on them, that's called a non-probate asset. And then you got the third type of asset, those things that don't have beneficiaries on them and are not in the trust. Now, a probate asset is kind of a pain in the neck, because in California, going through probate is a long, expensive, time-consuming, frustrating process. The typical fees for an attorney to settle an estate is the assets that are outside of the trust, is about 20 grand per $1 million of assets. Now it declines as the estate gets higher, but that's the statutory fee for settling $1 million estate, which you have one house in California and you're pretty much over that, depending on how much the mortgage is. So that brings up the will. The will is a document that says what is supposed to happen for your assets that are neither in the trust nor do they have beneficiaries on them. They are probate assets because you never bothered to change the name of the CD at the local bank or the brokerage account where dad was day trading stocks, or the checking account that the balance just got a little too high in. Okay, so those are probate assets. The will covers those. Now, the way we deal with them, mostly in California, is we have what's called a pour-over will. And the will is really short, couple of 2-3 pages. And the most that it says is the executor of the will is just like the trustee of the trust. It's the fiduciary. It's usually the same person. If you have the daughter as the trustee of the trust, you typically also have the daughter as the executor of the will. And just to make things more confusing, in California, we don't call them executors. We call them personal reps or personal representatives. Anyhow, it's the person that's supposed to clean up the mess that you left because you never checked if the rental property was in the trust. So those are probate assets. Those are covered by the will, and most wills in California, when drafted by an attorney, are what are called pour-over wills. That the only thing it says is the executor is supposed to pour over any assets that by accident I left outside of the trust. I want those assets to go into the trust. And the reason I want to do that is I already expressed my instructions within the trust. I spent a lot of time writing it up. I had an attorney help me. It cost a lot of money. I don't want to just leave it to whatever California says who should get my dough. I want to leave it to the trust where I have already expressed my intentions. So that's the will. That's the difference between a trust and a will. Most families ought to have a trust. If you've got a modest amount of money in or equity in your home, You want to have that in a trust because the probate process is about a year from start to finish, because there are not enough trust and estates judges or paralegals or appraisers or attorneys to help with these things. So everything's getting drawn out, and we got this mass of 10 million baby boomers that are just starting to die off and clogging up the system at the very time when the best judges and paralegals and appraisers, etc., are themselves retiring because they also are baby boomers. So to the best of your ability, try to get everything tucked into the trust, or set up beneficiary instructions that are correct and are coordinated with the trust. You should have a will, which is really an oops document. It's I made a mistake. I forgot to put the timeshare in the trust. And so now we have to go through this process of scooping it up and putting it in a trust. You don't do it with a pour over will. Hope that's helpful on the distinction between a trust and a will and when you need them. Ciao.